So congratulations, you formed your LLC. What many business owners don't realize is that's the first step. I'm Jonathan Feniak. I'm an attorney. I've helped thousands of entrepreneurs start their business across different states, and I've discovered that many LLCs lack a lot of critical documents and documentation that would actually help them deliver on the promise of limited liability protection and strengthen the limited liability protection they do have. So today I'm going to show you 5 different documents that really are often overlooked and why missing those documents really could undermine everything you've set out here to do. So let's start with operating agreement addendums. Things change, right? You have to sometimes change your operating agreement, especially if there's more than one person involved. Specialized amendments that customize the LLC operating agreement really are building on the framework of the initial operating agreement that you sign when you form your company. Oftentimes, people change their agreements with their partners, and they do it verbally. Right? They say, well, since you're working so hard on this, we're going to change the profit allocation. Or, the operating agreement said that managers can't get paid, but since you're doing all the managing, we're going to say that you can get now paid. Those sorts of things, doing it with a handshake, can come back to bite you. That should be an addendum to your operating agreement. If it affects the partnership itself, then you should put it in writing. Another potentially valuable addendum that isn't really a change to the operating agreement, but would be a change to one of the members of the company. If they get married, you may want to put in place an addendum regarding spousal consent. And particularly if you're in a community property state, once you get married, everything's part of the marital estate. This can prevent your LLC and your partners from being impacted from a divorce proceeding. So a lot of basic LLC formation services, they're providing generic agreements without considering your specific business situation, your personal situation, or state requirements. And so these addendums are not one size fits all. They got to reflect what's going on with the business. The answer is not to just do it on a handshake and an email. That operating agreement often is going to contain a provision that says any changes to the operating agreement require a signed writing. You have to agree to it in writing. An email or a text is not going to be enough to create something enforceable. It may be okay in the short term, but when it comes to long-term enforceability, you're definitely going to want to amend that operating agreement and put it in writing. Without it being in writing, people change, people deny things, people say it was not valid, and state law would tell you the operating agreement is really a contract, that it's not valid unless signed. So don't create unnecessary complications in the future if there is a member dispute. Do it now. Do that addendum, do the change, adopt the new operating agreement, whatever it takes to make sure that everyone's interests are represented and that everyone has agreement on the issues. We said a journey of 1,000 miles begins with one step. And the second overlooked document is one where you're taking one step a year. Okay. The operating agreement lays out the rules for the company. Okay. The articles of organization form the company. Okay. Annual meeting minutes. It's a little thing you go through with your partners and you say, what are we doing this year? Let's review what we did last year. How can we make the company better? What happened last year that created liability potentially that we did not properly document at the time? All of these things are important to get on paper. Why? Because real companies do this. Every company listed on the New York Stock Exchange or the NASDAQ or in the S&P has annual shareholder meetings. Much more complicated than what you're going to be doing, but having an annual meeting sets the tone for the company for the coming year, and it will allow your company to show in a court that this is a real company. This company holds annual meetings, and it's going to significantly reduce the chance that your veil, your corporate veil, your LLC veil is pierced, and this company is treated as nothing more than an alter ego of the owners. Courts typically look at a lot of different factors when they're determining if a company's veil should be pierced or not, and one of them is, are you observing corporate formalities? Annual meeting is an absolute corporate formality, and that is I want to plant a flag in that document and say that this company observes corporate formalities to avoid that. Those annual meetings might and should include things like, well, distributions to the members, right? Are there distributions being made to the members? If so, how much are those distributions? Working capital reserves. That is a key point in veil piercing. Is the company inadequately capitalized? Did you keep enough money in the company after your distributions to really address what you think the debts, the liabilities, sort of the issues with the company are going to be in the coming year? If you're zeroing the thing out and you don't have a reason why you did that, then that could be used against you because it can be treated as if the company is undercapitalized. Another important thing to have in the annual meeting minutes is going to be what is the direction of the company in the coming year. That gets everyone on the same page, and it really grants the authority to the other members to go forward with the company. If you're talking about we're going to really be changing gears and we're going to be each identifying real estate transactions for everyone to be able to participate in for the company, and any member can go out and find a deal and has the authority to sign off on a contract as long as it meets these parameters. Boom, you've put it in place now. Each member is able to go do those things. If you say the members have been focusing on real estate, but going forward, there'll be no more real estate deals, members should not be spending time on that, and no one has authority to sign on any documents related to real estate, put it in the meeting minutes, and then everyone's on the exact same page. These are both for exterior, outside third parties to view these annual meeting minutes, but it also helps keep the members on the same page. And so these important decisions that you're making, financial decisions and otherwise, getting them into those annual meeting minutes is going to pay dividends both in helping a company operate, assuming there's no litigation, assuming courts aren't looking at it, but it's also going to be really supportive of the idea that this company is real and it should enjoy all the statutory protections of limited liability laws. A third document, another step on that 1,000-mile journey, right, happens more frequently. And those are going to be resolutions or documentation supporting member manager decisions. I like to think about it like if we have three things that are going to happen in your company. And one is money goes in, meeting minutes. Money comes out, distribution, meeting minutes. Something that could get you sued, special meeting minutes. Those three things, that's the framework here we're looking at. Money going in. Why do we want meeting minutes for that? Well, is it a loan? Is it a capital contribution? What is it? What does that do to the member's interest in the company, right? Is it changing my interest? Am I buying a larger percentage of the company with this investment? If you don't document it, then it's going to be up in the air. Money coming out of the company, distributions from the company, those should be memorialized with documentation. Why did the money come out? It's a member distribution. It's a special distribution. One member's taking the money out right now, but the other one has the right to take that money out in the future if they want it. But in any case, their capital accounts will vary, blah, 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 say all these different things, right? Why is the money coming out? We are not taking money out of the company by using the company credit card to buy groceries or go on a cruise. The money comes out via distribution. It goes into the owner's or one of the owner's members' bank account. That should be properly recorded. Documenting decisions if that decision can get you sued. There's something called the business judgment rule. If you exercise business judgment related to decisions for your company and it turns out to be a bad decision, someone dies, someone is hurt, there's liability that's created. If you can establish that you exercise business judgment when making that decision, then the company should be held liable, but you personally should not be held liable. If you are making decisions that could get you sued, the decision to hire a new contractor to put a roof on your house, the decision to sign a contract of some sort, making business decisions that are properly documented and memorialized, if later on something happens, it is highly unlikely you are going to be held personally liable. If you don't document it, how do you prove that you exercise business judgment at some point in the future? I swear we thought about it and talked about it, Judge. It wasn't me personally deciding to hire my brother-in-law to do this job that he's completely unqualified for. We made a business decision to do it. Can you support that decision with some proper documentation? Incredibly important to avoid veil piercing, or not just veil piercing, but just member manager liability. As you having made the decision, they don't even need to pierce the veil if they can show that you made the decision based on your personal interest. They don't need to pierce the veil. They'll just hold you personally responsible for the decision. So documenting the fact that you made a decision that was in the best interest of the company and you exercised business judgment, huge protection for you and huge liability reduction. Fourth, banking documentation. We've said it, you gotta have a bank account. I said it, I'll say it again. You gotta have a bank account for your LLC. If you're operating your LLC out of your personal bank account, I think you, as I said in my prior video, don't even bother forming an LLC. Get the LLC bank account. All of the business transactions, whether it's the contribution to the company, the distribution for the company, hiring a contractor for the company, receiving payments from customers, all of that happens in the bank account. And the bank account is a great record of what is happening in the company's history. It's great audit protection. If you get audited, everything's in the bank account of the company. There's nothing to talk about. It's all right there. That was an expense. It was a business expense. We put it in the business. Here's documentation to show why it's a business expense. It was something that was maybe a little gray area. But having banking documentation and a really solid record of all the transactions related to the business, putting those in the business bank account, that is going to be incredibly powerful. Other areas of banking documentation are going to be authorized users. Who's authorized to access business accounts? Who's authorized to spend money out of business bank accounts, right? If everybody, all the members have all the authority in the world, you guys haven't put in any documentation related to no member can spend more than $1,000 without having a member meeting to approve that expense, you are putting the finances of the company at risk, either through misunderstanding of the members or just through some sort of malfeasance. If someone doesn't have the authority to go buy a Ferrari with the business bank account, that member or manager, and you've got documentation saying you may not do this, that person, you can go after them personally because they exceeded their authority. It's misappropriation of company funds, and you would have some recourse. If you don't have that documentation establishing that authority and somebody goes and buys a Ferrari, they could say, I was authorized to buy Ferraris because nobody said I couldn't, right? Which would be what the LLC operating agreement may say. So this is particularly important with multi-member LLCs. Having just the bank account doing all the transactions there, that's the important part for all LLCs. But when you've got multiple members and there's multiple people who may have access to bank accounts, understanding everyone, their authority over the company funds, that's a critical document that I would love to see more LLCs have in place. That documentation protects you from both these internal threats, internal risks, as well as external risks. So bank account information and clarity on it, critically important. This final section is about business continuity planning. I'm a downer sometimes. People die all the time in my conversations. Business owners die, okay? Unfortunate fact of life. What happens if you die? What happens if you have a partner in the business and you die? What happens if you have no partners in the business and you die? What happens if you're incapacitated? You don't die and you just can't take care of the business. Do you have systems in place, documentation in place that establish what happens in those scenarios? For multi-member LLCs, having an operating agreement that lays out what happens. Your kids, even if they're the heirs to your estate, don't get to be managers and operate the business. That initial owner, I should say your initial partner, would be the one who maintains full control. Maybe you're okay. Maybe your partner's okay with your kids being their new business partners. Spouses. Does your spouse get to be a manager or member of the company if you pass away? What happens if you pass away? Does anyone have authority over company bank accounts at that point? Or does the company go into a nosedive because they need to wait? You've got contracts on the line. You got materials you got to deliver. You got things that need to be done. But there's nobody who can go to the vendor and say, hey, sorry, Johnny died, but I have full authority. Here's a document. I have full authority to act on the company's behalf while his estate is being probated. Do you have that in place? Does the operating agreement say that? Is there some sort of continuity plan in place? There's a lot of different ways to address a lot of the things we talked about here, right? The important part is that there's something. There's a document. You talk with an attorney, you do your research, and you figure out what is the best path for you and your partners or you and your family when it comes to this continuity planning. Don't stick your head in the sand and think that it's all going to work out, think you're not going to die. bad things do happen. So incredibly important to get something in place now before there's an issue. If you're concerned that your LLC may be missing some of these protections, you are not alone, because most people don't even know you've taken at least the first step. They don't even know they're supposed to have these things. But the good news is that evaluating your documents, you've taken this first step, watch this video, you should be able to go and evaluate where you stand right now and remedy the situation, potentially in the past or at least going forward. An LLC attorney, we actually care about ensuring that you get the limited liability protection you signed up for. And we've developed the documentation inside our client portal. You can get documents related to these 5 issues or consult with an attorney who has expertise and can assist you with walking through these concepts, figuring out what's best for you. You can go to llcattorney.com. You could start your business, ensure you have the proper documentation right from the start, and schedule time with an attorney if that's needed. But thanks for watching, and I'll see you in the next video here to help you really navigate the specific documentation that you are going to need for your company.